Thank you, Speaker. My question is to the Premier. I refer to the legislation passed this parliament last night that seeks to deal with damages claims submitted by Clive Palmer, Mineralogy and International Minerals, against the state of Western Australia. And I ask, can the Premier advise the House what is at risk for the people of Western Australia if this legislation is unnecessarily held up and delayed by a parliamentary committee? And can the Premier advise the House if the action this government is taking to protect the interests of Western Australia could have been avoided?
Premier.
Thank you, Mr. Speaker. On the most critical and time-sensitive, I'd like to comment on the most critical and time-sensitive issue in Western Australia today. I'd like to pass on my thanks to members of this House who passed the legislation in relation to mineralogy last evening, for progressing an essential bill to protect the interests of the people of Western Australia. Just want to remind people what is at risk here. It was canvassed by the Attorney-General yesterday. The cost of failure in relation to this matter is extreme. Never before have damages been sought under an arbitration process in relation to a State Agreement Act. And we have 70 of those State Agreement Acts, and they go back 80 or so years in Western Australia. Never before have they been sought to be arbitrated, and never before have damages been sought by any party in relation to these matters. The position taken by Mr Clive Palmer is that he is seeking a payment from the taxpayers of Western Australia of around $30 billion, 30,000 million, $12,000 per person in Western Australia, plus further unspecified damages for other breaches he claims the former government made. That would mean it is well in excess of $30 billion. It is good that the bill passed the Assembly last night. It was good the bill passed the Assembly last night, and I'd urge all MPs in both houses to support the passage of the bill today. Members would be aware that yesterday Mr Clive Palmer began proceedings to try to register his arbitration in the New South Wales Supreme Court. I understand he has also filed an application in the Queensland Supreme Court. It is essential that for whatever legal wrangling that follows, Western Australia is in the strongest position possible to protect our state when the lawyers have it out in New South Wales and Queensland. It is in the interests of this state that during any proceedings or discussion in the New South Wales or Queensland Supreme Courts, they are discussing an act of the West Australian Parliament which settles the matter, passed with the signature of the Governor upon it. Western Australia's case is far stronger if this legislation is passed today. We cannot have a parliamentary committee taking 4 to 6 weeks to consider this legislation. This is urgent. This is not some game. Mr Speaker, it could be disastrous if the legislation is delayed. Now, Mr Speaker, people across West Australia are asking, could all of this have been avoided? Now, let me be clear. As was canvassed in the media, and I've been very clear publicly about this, my government and myself personally believe that Premier Colin Barnett made the right decision and took the right course of action when, as State Development Minister, he protected Western Australia at the time from a proposal by Mr Palmer that was flawed and without appropriate detail. Mr Barnett made the right decision. We want to back in Mr Barnett and the former government's decision here. But it has come to our attention this morning that there was advice given to the government in 2014 that could have potentially put a stop to this whole sorry saga then and there. Following the handing down of the arbitral award by Mr McHugh AC QC on the 20th of May 2014, advice was provided by the State Solicitor's Office concerning whether or not the state should appeal. That advice was provided in late May 2014 by Mr Robert Mitchell SC, who is now the Honourable Justice of Appeal Mitchell SC. While that advice is not available to the current government, I have here a memo from Nicholas Egan, the State Solicitor. The memo confirms the previous Liberal government was advised to appeal the award in 2014, and that self-evidently that advice was not followed by the government of the day at ministerial level. For the benefit of the House, I now seek to table the memo.
Paper table.
Mr Speaker, there was the opportunity to protect the taxpayers of Western Australia that the former government chose not to adopt. What is done is done. I cannot undo the inaction of the past, but we can do our best to rectify the situation we now face. Can I urge everyone, please abandon efforts to delay this legislation. Please support the people of Western Australia. This is an extremely important matter. I urge the Legislative Council, I urge the Liberal Party, please help us undo the issues that have occurred in the past. Please help us undo the issues in the Legislative Council. Please help us get this legislation through. This legislation is designed to protect the taxpayers of Western Australia from a rapacious and greedy claim by a Queensland billionaire that would potentially bankrupt the state of Western Australia. You have an obligation here. You have an obligation to help us. You have an obligation to do the right thing by the people of Western Australia. This is not a joke. This is not a game. This is one of the most serious issues this parliament will deal with. Please assist us here. We do not have the numbers in the upper house. We rely upon the opposition to help us. The ball is now in the Liberal Party's court. Help us resolve this matter.
Darling range.